clear, I sat through this trial for 8 weeks. The government's focus from beginning to end was on trafficking and the RICO. The whole, where the debate was there coercion or was this voluntary?
Right.
That was the gist
The Mann
of
Act
what
was an
being
afterthought.
disputed.
It was an afterthought. The Mann Act was just an afterthought in the
Correct.
government's prosecution. I mean, it was there, but it was effectively a sideshow. But that's the question, right? Can the government then look to all this, can the district court look to evidence presumably rejected by the jury and acquitting on these other things for purposes of finding the penalty in this sideshow? And why shouldn't we just hold the government to what it argued?
We should. We should, absolutely.
I think Diddy is coming home, bro. Don't hold me to it, but this is just a thought. Because listen to what this judge says. It's 5 minutes, but I'm going to explain it perfectly. Trust me, you don't want to miss this.
Properly considered by the judge to figure out, did Mr. Combs really intend what was all going to happen was going to happen? Let's just posit that. But isn't there a world in which the guidelines say, yeah, you know what, that's fine. Consider it for purposes of the Mann Act elements. But you can't draw the further conclusion that that was coercive in nature.
Well, the guidelines...
Because that's what the jury said did not happen, or did not find happened, and therefore it's acquitted conduct.
So I think because this acquitted conduct tends to prove an element of the Mann Act.
But how does the coercive nature of it, the inference that it was coercive, because I think that's really a distinct fact, right?
That inference is coercion is defined in the guideline. The fraud and coercion guideline, or excuse me, enhancement is set out in the guideline. And the definition under that, coercion under that enhancement.
Let's assume it is coercive conduct. I think what Judge Nardini's asking, and I have the same question, is how does the fact of its coerciveness tend to establish some, in whole or in part, an element of the Mann Act offense?
Hey, hold on. Before we go, QR code or tap that link in the description. That's free cash setting ads. Get paid on a Friday. Yeah, get paid on a Friday or 5 day. Soon as you got to put the app in your phone, you got to start playing some games. That's it. We're going to put that 5 in there once you do that. After you do it, some of y'all are like, I went there, bro, but it didn't say automatically. No, you got to install it on your phone and start playing some games. That's when we do it. You start seeing the money start to pile up as soon as you start putting in the right stuff. So click right here or click right there and get $5 on me. Free cash, setting ads. Let's get on with the content.
I think it relates to the temporal proximity between the coercion, the threats, I'll call it, the threats, the transport, and the demand for a freak-off.
So let's say the conversation instead was, instead of it being coercive on the plane, was when we get back, my plan is to fly some escorts in and you're going to have sex with them, and I'm going to pay them for that.
Sure. I think that would establish the intent.
Exactly. So why is the additional aspect of that conversation, that encounter on the plane that's described, that the coercive aspect of that, why is that add anything to establish in whole or in part the Mann Act offense?
Because I think it's what he's asking for. It's the threats are not followed by a request to go to dinner, a request to ask Cassie to do the dishes. Those threats are followed by a demand for a freak-off. So the coercive nature of the threats are directly relevant to the intent to have the freak-off, which then later happens.
Well, okay. Except you've agreed that it didn't need to be coercive in order to support that aspect, the intent
No, not
aspect
necessarily.
of the Mann
It
Act.
just so happened in these two specific instances, the threats did amount to coercion under the enhancement. And I think that was, I think Judge Subramanian...
Can I ask you a hypothetical? And I don't know, it doesn't map onto this case, but I'm trying to make sense of the acquitted conduct guideline. We have a defendant who's charged with murder. He points a gun at the victim's head. He pulls the trigger at point blank range, kills the victim. He's charged with first and second degree murder. The jury acquits of first degree, which would have required a finding of premeditation, but it convicts of second degree murder. Let's say it was, I don't know, some sort of heat of passion or something he just did on the moment. Comes to sentencing. Is the premeditation, which is purely mens rea, in your view, acquitted conduct or not? And if so, is the judge, in my hypothetical, allowed to make a finding of premeditation by a preponderance and sentence the defendant accordingly under the guidelines?
So the premeditation, I think.
Because what I'm trying to do is draw a distinction between the actions, the physical actions, and I'm going to analogize that to Mr. Combs coming back in the plane, sitting next to Ms. Ventura, showing the video, saying the words he said. Those are sort of raw facts.
Mm-hmm.
Clearly, they underlie, in my hypothetical, clearly the underlying facts of the man reaching over with a gun, pulling the trigger, and killing a victim are raw facts. Clearly, in my hypothetical, they underlie the second-degree murder conviction.
Sure.
But the jury has acquitted on first-degree murder, meaning they have not found premeditation beyond a reasonable doubt. It seems to me that if we pursue the government's theory here, which is you can consider the facts surrounding the walking back in the plane, the showing the videos and all that, and then the judge can draw whatever inferences the judge thinks appropriate because the facts were properly before the jury on account of conviction, then the judge, in my hypothetical, would be able to find premeditation beyond by preponderance and sentence accordingly under the guidelines amendment. Is that your view?
I think that's right. I think that's right, Judge.
Yeah, you heard right. You 100% heard right. The judge said basically this, yo, if I do something that's bad, all right, we agreed all of this shit, but it's not to the higher level. Like first degree murder requires premeditation, meaning I thought this out, which means you can give me the death penalty. If we go to a lower second degree murder where I kill you, but it wasn't intentionally done, I just killed you out of just my emotions and all that, you can't, due to how the guidelines are, you can't give me the death penalty. And the judge basically say, yeah, we just gonna give you the death penalty anyways. That's the whole argument. The argument is, bruh, the jury said they did not find this guilty, but you charging me off of this shit like I'm guilty. What I'm convicted of is actually lesser than the 4 years that you're giving me. And when the judges, it's 3 judges, they rip into the prosecution because Judge Subramanian was wrong in his sentencing. We had a 4-week, 8-week trial, however long this shit went. They did this shit for weeks. And all you came back was a Mann Act violation. 2 of them. All right, cool. But the way that the sentencing was supposed to be, they OD'd. Flat out. So the freaking judges is like, hold the hell on. You can't do that. What's the point of the jury? What's the point of us doing a whole jury trial and basically not doing this shit that the jury trial said, that the juror said, pardon me. And when we said this stuff in the beginning, everybody was pussyfooting around it. Everybody, from me to y'all to nobody. I'm playing on that. But when I say y'all, I mean people who are subscribed to the channel, to the ones who only tuned in for the Diddy coverage. Everybody kept saying the same shit. Bro, this judge is biased as hell. And then when he wrote this shit, hey, I hear you. To the victims, I hear you. Hell nah. Keep listening to this shit. It get crazy.
Presented as this evidence relates to sex trafficking and this evidence relates to the Mann Act. There was never a dividing line.
But when you get to summation, there is, right? So you say, let's start with count 3. The defendant is charged in count 3 with interstate transportation for the purpose of prostitution related to freak-offs involving Cassie. That's how you describe count 3. I think that's right. And then you go on to talk about all of the evidence about escorts traveling. And it doesn't talk in your discussion of count 3, and similarly, it's a very, very mirrored for count 5 when you talk about Jane Doe. Doesn't talk about Ms. Ventura or Ms. Doe being coerced, or Ms. Ventura or Ms. Doe being transported. It says count 3 is about escorts traveling for the purposes of contact with Cassie, and count 5 is about escorts traveling for the purpose of contact with Jane. As Judge Baker is saying, where else can we divine the government's theory of those 2 counts other than summation, and why shouldn't we hold you to it?
So just to be clear, the government's theory was that the travel involved both Cassie and Jane and escorts. But
why
I think
isn't that what you said in your closing?
I don't have the exact words of the closing, but that was.
I do.
I think that your other question is, why shouldn't the government be held to what it argues?
Let me just stop you for a second, because the last thing you say on count 3 is, quote, all of the examples that I just went over showed the defendant caused commercial sex workers to travel across state lines for freak-offs. The defendant is guilty of count 3 based on any single one of these instances. Then you say, let's move to count 5. So that's how you started and ended count 3.
So the point was, the government, in closing, went over several examples. It was not a comprehensive list of all the instances of travel because...
No, but the theory was that he caused commercial sex workers to travel. That was the theory on which you asked the jury to convict Mr. Combs on count 3.
Sure.
Not that he caused Ms. Ventura to travel or that he coerced Ms. Ventura into something. The theory was he caused commercial sex workers to travel. Other than the constitutional challenges, there's no sufficiency of the evidence challenge to that for good reason. It looks pretty much like he did. But that's the government's theory, right?
That was the government's argument at closing. I think, kind of backing up, the import of this line of questioning is, shouldn't we hold the government to what it argued in closing? And I don't think that that's right. I think the theory is, if the government made this argument, doesn't that mean that the jury accepted that argument and didn't consider any other possibilities? And I don't think that that's a fair inference.
But what we're trying to do here is to figure out where, draw this line. So the jury acquitted on certain things and then convicted on other things. So what does a jury have to rely upon? Don't you think they're listening very intently to the closing argument? Isn't that going to be very, very important in their consideration?
Of course, Your Honor, of course. But the jury in this case, was properly instructed on each element of the Mann Act and had to find each element of the Mann Act met beyond a reasonable doubt. And I think it's, as a logical matter, I think it's an impossible task to discern the minimum quantum of evidence that would be sufficient to sustain the government's burden. And I think that sort of inquiry also goes against this court's precedent.
The feds is like this. This is what they saying. Y'all said that the dudes who traveled, the workers, that's the Mann Act, not the ladies. Y'all saying that. Hold on. So y'all made all of this noise and all this static that the dudes were the people who essentially were the victims. But now y'all said, no, wait. It's the women. And so in the beginning clip that I tell y'all, bro, they said, why don't you hold the feds to what they said? Bro, the feds is ripping the shit. The feds are getting the shit ripped out of them by the judge. I never thought this was gonna go like this, bro. I'm sorry. It's looking like, bro, Diddy should have never been convicted. Now all the people who say, nah, Nash, you was wrong, y'all got your case right here because they right, bro. You switching it up. You're switching it up, feds. I'm arguing that, yeah, he did this to this woman and this to this woman and this to this woman, but I make no argument about this in the end because they flat out, well, she said, oh, I don't know what I said in my closing. The judge like, I know what you said. It's right here. God damn it. Let's go with this last clip, bro. I'm loving this shit. I probably do need to go sign up for law school, bro. I'm loving this shit. I know there's going to be a lawyer who's going to take these clips and destroy the shit out of the fans with this one. I might have to send her this video.
And moreover, in determining the appropriate sentence under Section 3553A, Judge Subramanian properly considered the aggravated manner in which the defendant carried out his Mann Act offenses, which is, of course, consistent.
You say aggravated manner. Let's talk about that. Why shouldn't we hold you to the way you prosecuted the case? You went to the jury and you said, this man did all these terrible things for purposes of the RICO conspiracy, for purposes of sex trafficking, and they acquitted him. And then on the Mann Act, it was just a sideshow, and you put him. I don't think there was any evidence or any live witness testimony. Just look at this, you said, look at these charts. And now you want us to rely on all this acquitted conduct that was presented to the jury that was presumably rejected for purposes of, or to allow a district court for purposes of the guidelines calculation. So why shouldn't we hold you to what you argued to the jury?
Your Honor, I have several responses, but
Please.
first is that much of the conduct that the district court focused on in imposing the sentence was not acquitted conduct at all. In fact, it was admitted conduct. The extreme physical violence that took place in the context of these freak-offs
That's
and
not,
hotel...
okay, I get all that. I understand that. That's not my question to you. My question to you is, why shouldn't we hold, it's not what the government's, what the district court relied upon. I'm asking why we shouldn't hold you in terms, require a district court to hold the government to what it presented to the jury for purposes of, for deciding the scope of acquitted conduct, to look at what you actually presented to the jury for purposes of those charges, and then asking, did it overlap with the acquitted charges? And I don't think there's any overlap here.
Sure.
Basically, y'all try to set up this big old case about all of this stuff and this crazy shit that happened, and the jury said, we're not buying it. The jury said, we're not buying it. So you guys went for the lesser charge like the feds do. This was the same shit, and I'll give Lawyer for Workers his credit when he said what he said, basically, where he said, yo, the stalking charge for the Lil Durk case is the one that they trying to really get him on. They know the murder for hire shit ain't gonna work. He's right on that. And that's basically what the feds did. They said, oh, we can't get him on the drugs, the beatings, the R's, the all of this shit. No, but we gonna get him on the Mann Act, and we gonna fire his ass up for that. You overpunished. That's what happened, bro. I believe Diddy's gonna win this appeal, bro. I've never in my life ever heard of judges sounding like this pro-defense based off of evidence and facts that the damn prosecution used. For those who are still slightly confused, it goes like this. You have let's give you a brother, right? And y'all got in trouble when y'all were kids. And you were there, right? And you defend your brother to your, let's say, your mom. Let's make it a dad, because dad's typically, well, moms are really the ones that tan your hides. So you sitting up there trying to tell your mom, no, wait. He actually didn't do all of these things. And then your mom go, well, normally I would kick his butt and give him about 10 slashes on the broad part of his butt. Tear that ass up 10 times. He gonna get 10 swipes if he would have did all this crap. But you know what? You convinced me that he didn't. But he did do this little stuff over here. So I'm gonna give him 8. And you like, Mom, normally you'd give him like 2 slashes for that one. You gonna give him 8? Hold on, it's only you gonna give him 8? But it's not only that you're going to give him 8. You're going to give him 8 after you done already gave him 1. You smacked the... You did the whole... Wait. Where I get the 1 from is because Diddy has spent damn near a year in jail before he even got sentenced. So, bro, I'm going to be fair. I think Diddy coming home, bro. I think Diddy is coming home. That shit right there was a shit show. But y'all, let me know y'all thoughts on this one. This is the hood lawyer part that I thoroughly enjoy. But we gonna be fair, square, obvious, and honest. Stranger things have happened. They might say, you know what? The 4 years ain't that bad. They might say that. But from how it sounds, they may say that was enough, bro. He can go ahead and go. Let me know your thoughts on this one, though. Y'all with me, or y'all like, nah, bruh. Hell nah. Ugh. Click right here, though, to see how Gucci Mane's lyrics could be used in court for the defense. He said some things that went against what the feds said, and I just wanted to point them out. Click right here for that, or click right here for the playlist. I'll catch you on the next one.